This is Committable. I'm Jesse Mangan, and for this episode, we're going to be talking about protection and advocacy organizations. And I'm very lucky to have with me here Tim Clune and Jennifer Monthie from Disability Rights New York. Tim, do you want to introduce yourself? Say whatever you want about who you are and the type of work you do.
Great. Thanks, Jesse. First, it's great to be here. So I am Tim Clune. I am the Executive Director of Disability Rights New York. I have been with the organization since 1990. Back then, we were a very small 7-person office providing services to people with disabilities in the Hudson Valley. And then in 2013, we became the statewide Protection and Advocacy and Client Assistance Program office, and I can talk about that a little bit later.
Awesome. Thank you. And Jennifer, want to introduce yourself?
Hi, thank you for having me. I'm Jennifer Monthie. I'm the legal director at Disability Rights New York.
Uh, Thank you for being here. So I think a lot of people don't really understand what a P&A is. So the first question is, what is a protection and advocacy organization?
Great. So can I give a little bit of a history lesson here?
Please.
So New York has had um, not such a great reputation, providing services to people with disabilities who were living in congregate care institutions. So I'm going to take you back to the 1880s when Nellie Bly, who was she was an investigative reporter, and she had herself committed to the Blackwell Island, and back then it was called an asylum for people with mental health diagnosis. So she was there for 10 days, and as a result of her reporting, she, put a spotlight on the lack of appropriate care to people with mental health diagnoses. And the result was additional funding was provided to provide services to people with disabilities back then. Blackwell Island is also known as Roosevelt Island, down in the city. So that's where it was. The facility closed many, many years later. So that was in the 1880s, 1890s. Um, Fast forward to the 1930s, the late 1930s, um, Willowbrook was was built, and it was built on Staten Island, and it became operational in the late 1940s. It was to provide institutional care to people with intellectual and developmental disabilities. It was supposed to be a smaller facility that housed 4,000 people. Over the course of time, that number, exponentially increased, and the overcrowding was just not a tenable model to provide services to people with disabilities. The There were rumors and then validation of really, really hard conditions that existed there in the 1950s and the 1960s. And the facility they were conducting experiments on people who were living there. They injected people who lived there with hepatitis, and as a result, it was just creating what Senator Kennedy called back then a snake pit. Um, Senator Kennedy, Bobby Kennedy, back then, he visited the facility in 1965. He toured it. He spoke on the steps of the facility to describe the horrid conditions there, yet nothing really ever happened. It was only until 1972 when Geraldo Rivera took a camera crew into the facility, and he uncovered, the actual physical abuse that you could see on screen. I remember at that time I was around 12 years old, living in Ridgewood, right on the border of Brooklyn and Queens, so not far from Staten Island. And I remember vividly when his expose was 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 published on TV and watched it. Um, the horror that was sent through, the citizenry, throughout the United States really had an impact on the public view as well as the elected's view of what was going on there. As a result of his expose, there were hearings held in Congress, and eventually the the 1970, Developmental Disability Act, that's a much longer word, but was was amended to create the Protection and Advocacy System. So this was in 1975. And the Protection and Advocacy System was created to ensure that there was independent oversight of the services and conditions in institutional care to ensure that anybody who was a resident or a patient there was receiving appropriate care and services. So that that was back in 1975.
I think one of the things that's amazing about laying that all out is from Nellie Bly, whose work was really sort of carried on in the 1960s by David Rosenhan, who did another study on being sane in insane places, which raised a lot of questions. And you've got a lot going on in the 70s with Geraldo Rivera and Senator Kennedy raising these questions, and then you have federal cases. I believe Lassard happens in around 74. And so right at this forefront of all this change, protection and advocacy organizations are created, and they're appointed by a governor, and they have the authority to monitor and potentially open an investigation if they hear reports of abuse. Can you talk a little bit about those two sort of obligations, those two responsibilities, monitoring and investigation? What does the monitoring authority look like throughout your sort of, I guess, daily, weekly, monthly duties? Do you have people going to facilities every day? Do you have um, other means of monitoring nowadays?
Can we do a two-part answer to this? I'll take the
Please.
first part and Jennifer will do the second part. So the additional history regarding the protection and advocacy for New York is when the P&A was created, it was housed in a New York State agency. So the legislation that created the P&A allowed for the governor to designate a not-for-profit or have it housed in a New York State agency. So for decades, the P&A was housed in a New York State agency. And in the 2011, maybe, the federal oversight agencies had done a review of New York State and concluded that New York State was not in compliance with the independence. And this is where the monitoring and investigations is going to dovetail to your question, but was not sufficiently independent because it was housed in an executive agency that is overseen by the governor. And the whole point of having the protection and advocacy system was to have an independent, not tied to the governor, agency that could point out, problematic and systematic problems that existed and address those. Um, our office was created back in the 1980s, and we were a contractor with the state P&A back then to provide the legal monitoring and investigative components of the P&A system. When the federal oversight partners came in and did their review, they required the governor to designate a not-for-profit so that the independence requirement of the protection and advocacy statute would be, there'd be fidelity to that. Um, our office, Disability Rights New York was well suited at that time to be designated. So we became the statewide protection and advocacy system, we were designated on May 7th, 2013, and we became operational on June 1st, 2013. But we had been providing these contract services, the P&A services, since 1988. So we have a long history of doing it. And it was at that time that we then had the full power of the PNA, and it was completely divested from the state. We have responsibilities to represent people and to do investigation and monitoring. So before I turn it over to Jennifer, does that change some of the part of your question?
Um, so I think part of the question that I might amend would be that you're receiving a series of different grants from the federal government, and each one of those grants is designated for a specific population or a specific concern. How does that impact monitoring? Do you have to look to the resources provided by the grant and determine what does this specific grant require us to do? Do you have to do that with every single one?
Let me let Jen jump in at this point.
Sure, and I'll answer your question, and I think what I heard from the other question kind of tends together. So, as Tim laid out, Congress created this protection advocacy system to just be very clear, because I think it's such a unique system in its creation. The charge from Congress, I like to think of it as threefold. One is to monitor, and I'll talk about what monitoring really means under the PNA system. Two is to investigate, and the third is to advocate. So in terms of monitoring, the way Congress envisioned monitoring is to conduct reviews of places that people with disabilities receive services and educate the people within those service systems about what their rights are. So it isn't triggered by a particular allegation of abuse and neglect. It's an ongoing oversight of how are federal dollars, because mostly these services are delivered through Medicaid dollars, how are Medicaid dollars being used in the states to deliver services to people with disabilities? And do the people who are receiving those services understand what their rights and responsibilities are? So that's monitoring. Investigation is very broadly defined in the PNA Acts, even more broadly than maybe what an oversight force or a criminal justice sort of system thinks about in terms of investigation. Because what can trigger an investigation in the PNA system can be anonymous complaints, can be newspaper articles, can be, hearsay, some complaint about what the system calls abuse and neglect. And the term abuse and neglect within the PNA system is equally as broad and is not confined by what maybe the general public might think about being abuse and neglect, which is physical or sexual assault, or all of those concepts that were existing at the time that Willowbrook, the scandal came through. So failure to implement a discharge plan is neglect. And so the broad nature of it is purposeful in my estimation from what Congress set up, because at the time you have an institutional model in New York State, and Willowbrook was not the only institutions that were being operated across the country, where care was known to be poor, where people were known to be in squalid conditions, yet nothing was being done because it was an underfunded system, an under-resourced system where people were sort of just being warehoused. And so instead of just looking for the abuse, what Congress wanted a system to do was to oversee the entirety of it, to make sure that federal dollars were being used in a way that didn't lead to abuse. And then finally, you have a lot of oversight entities that are sort of created throughout the United States, right? They're created at local levels, they're created at state levels, they're created at federal levels. But what's unique about the PNA system is that Congress also gave it the authority to then go advocate for the people who are subjected to the abuse and neglect or rights violations. It had that dual role. So not just exposing the abuse and neglect, but then advocating for change. And that's what I think makes the PNA system so effective at finding that change, is that once you expose it, you're not I guess, reliant on the system itself to fix it. There are means that the P&A system can engage in to seek reform of the problems within the system, and it's specifically charged to do that. To answer your question about the different programs, we really didn't, for your listeners, get into the fact that the first program that Tim talked about was the program for people with intellectual and developmental disabilities. Fast forward today, 50 years later, Congress continued over that 50 years to expand the Protection Advocacy Program to not just target people with intellectual and developmental disabilities, but to target all people with disabilities. And examples of this could be, Tim started with concerns talking about concerns in our mental health system. That was the second program that was created. It was program targeted for people with mental health diagnoses. And then Congress then expanded it again to deal with individuals that don't qualify as having an intellectual and developmental disability or a mental health diagnosis. And generally that's people that might have sensorial disabilities or physical disabilities, because care in other types of congregate models also had the same concerns that the models that we've already described had. Each time the federal government appears to be distributing funding to states and territories for delivering on an objective related to people with disabilities, we do see a protection advocacy component often tied to it. So when the Ticket to Work program was passed, which I won't get into, people can Google about, there was a protection advocacy system that was expanded to deal with the rights of people to get back to work who are beneficiaries of Social Security. You have the same thing with assistive technology and traumatic brain injury. The whole scope of the program, though, is that no matter what disability you might have, you can come to the protection advocacy system and receive protection advocacy services, because that is the breadth now of the system after 50 years. Your question was about monitoring and how you choose it, right? So obviously programs have limited funding, right? Each Congress designates a certain amount of program funding for these protection advocacy systems across the United States. There's one in every state and territory, and decisions have to be made in terms of prioritizing that funding. And I can tell you today, there are more requests for our services than we have funding for. That's both on the direct advocacy side of our responsibility, as well as our investigation and monitoring side of our responsibility. And I think that's going to be true no matter how much funding you get. The complaints are often outweighed by the amount of resources we have to investigate them. So yearly, the protection advocacy system has to set up priorities, and we do that. We take feedback from the community on those priorities, and monitoring is often a great tool for identifying investigations, because in monitoring you can do more outreach to the community of people that you're serving to find out where the problems are, and then you can identify your investigations from the problems that you discover during monitoring. And that education is not, you can also reduce the amount of investigations you have to conduct because of monitoring, because you can educate the service provider about what their responsibilities are to reduce the likelihood of abuse and neglect occurring within those systems. And so in terms of your question on monitoring, it is resource driven, how much monitoring that we can do. But that effort is targeted in certain ways based upon the experience of the P&A. And what's unique about the P&A system is because it's broken down by state and territory, it can have a very local response to monitoring and investigation that a nationwide system that would be operated by one entity might not be able to have, because we are in the communities that we're serving.
Yeah, it's kind of incredible that not only is there the localized, but there is the ability to be independent within a state, which seems so vitally important. And it sounds like every type of facility, state-run facility, private-run facilities, schools, prisons, jails, everywhere is a place where people with disabilities are going to interact. So monitoring, that investigation responsibility extends to all of that. One thing I am curious about is, with limited resources and the overwhelming number of complaints and contacts with people who have concerns, how do you filter out the things that you can respond to? Because I imagine sometimes every person making a complaint has should be considered valid. Like that they need to be acknowledged. Their humanity needs to be acknowledged. But sometimes, even when a process is traumatizing or stigmatizing, dehumanizing, it's not necessarily illegal. So when you receive all of this information, all of these complaints and data points from the community, what is the process of that you go through to figure out which are the ones we can actually take action on, or which are the ones that indicate trends that we can look at?
So, Jen, can I start and then it'll flow to you? Um, all of our programs have created priorities and objectives. What we do is we reach out to the community, to the people who are impacted by the particular programs, and every year we review those priorities with with also a view towards what our resources are to realistically and effectively deal with the particular programs, the particular problems. One of the things we also have at DRNY, which I think is unique on some level, is we do not have a telephone touch torture system. So when someone calls the office, they get to communicate with a live person. It is not, if you have, X problem, press one. If you have this problem, press two. We strive to ensure that when people are contacting us, and let's just be clear, when they are calling us, it is not a good day for them, right? There are things going on in their lives that oftentimes we cannot imagine. So we created a system and an intake system to address that particular need because it is a need. When someone contacts the office at their most dire time of need, one needs to communicate with a human being. Our intake department right now is we have 9 people who staff our intake department. Um, they know what the priorities are. They do a great job assessing because they have access to everything that's coming in and whether it is the systemic issues. So if they have been given direction by one of the programs, hey, we need you um, to keep an eye out for X, Y, or Z problem, and then um, send it over to the program. But we ensure that everybody who contacts us, they get substantive help. And it may only be in terms of technical assistance to help you self-advocate, maybe direction to someplace else where we can't help people, but we are fully cognizant that we may have we're looking for particular problems that present a more systemic issue. Without more, that's little consolation to the person who's contacting us with that problem that is, pretty significant to them at that time. So we really, strive to ensure that we are providing, a service to the person that has left them off better than when they had contacted us in the first instance, if we're not able to take it any further. So I'll let Jen get more into the specifics of.
Sure. So I would say to continue where Tim left off, when you're responsible for an entire state and anywhere a person with a disability might be for complaints of abuse, neglect, and at the resource level that the PNA system is funded, there's absolutely no possibility that you're covering every complaint of abuse and neglect. But I don't think that we see the system that way. There are state oversight and entities. There are other nonprofit partners. There are other funded entities that are responsible for investigating abuse and neglect. And at the PNA, we see ourselves as a hub to get people where they need to get in some places. And we are the stopgap at the end of the day. So oftentimes where we're prioritizing monitoring or abuse and neglect investigations are places where we have identified gaps where there is absolutely no oversight, whether from state entities, local entities, or other nonprofits. And we are seeing trends related to the care and treatment that people are receiving in those settings. So we have those as maybe our priorities on the top priority one. There are other places where we partner with other groups that are in those locations to be on the ground and say we are seeing a trend. And the authority given to you is the P&A, which is you can knock on the door whenever you want to and make an unannounced visit, would be a good authority to use to check to make sure that when we're seeing it cleaned up after the fact, but we don't see the unannounced component of it. And so there's some advantages to, the P&A conducting the monitoring or conducting the investigations. What trends comes from, I think, going back to the real value of this system is having both an advocacy responsibility and an investigative responsibility, so that when we're out doing advocacy, we can use that data to trend towards concerns that we're finding. So if we are getting people asking for legal help because their children are being abused on buses, we can look at it much broader than just the one client who, was hit on a bus, right? What does the whole busing system look like in this particular school district? Or if we are helping a individual who is not getting discharge planning in a nursing facility because their paperwork keeps getting lost, we can look and say, are you having a discharge planning problem across your entire system here? And that may come from the individual case, may be closed as a technical assistance. Here's what you need to do in order to get your paperwork heard. Or school child, here's the state agency you need to file this complaint with if you're dissatisfied with your educational services. But then we might look at the bigger picture to make sure that other people aren't being impacted across that system.
So it sounds like the intake unit is essentially like triage in a way. You're taking in all of the immediate concerns and you're filtering out the ones that need to be dealt with right now or can be dealt with right now, and then finding appropriate agencies where possible. You sort of triage, and then you're an intermediary as well. You're finding other places.
Yeah, exactly. And I do think it's really important to understand that what we have found in the P&A is the complaints of abuse and neglect are not likely coming through your intake system. You have to be out in your community. So they can come through a newspaper article, they can come from anywhere you see them, but people often don't call up someplace and say they're being abused, because people who are being abused often don't know that they are being abused. They don't know what their rights are. So that's why monitoring is so important, going out to places to make sure people know what their rights are. But people, the complaints of Willowbrook did not come from residents of Willowbrook saying, I'm being abused. Mm-hmm. They came from staff within those facilities saying that this is wrong. And so that's where, it's not necessarily our advocacy unit that is going to uncover tremendous problems with abuse and neglect. Our connections to our communities and to the other people serving our communities is really critical to uncover really hidden abuse within these service systems.
Yeah, a question that raises for me, because I think it could be easy to view P&A and a state as adversarial because you are independent, you have monitoring, you're essentially a watchdog sort of organization. So it could be easy to view them as adversarial, but it sounds like what you're saying is you have to rely on people in facilities, the staff, the people, the clinicians, whoever. You have to rely on them to identify trends and to bring concerns to you. So you have to develop relationships with all of these places. Is that right? You have to basically find people who are willing to speak up in a whistleblower kind of capacity in order to figure out where your services are needed. Is that right?
I don't know if I would say the word isn't rely, because
Okay.
I think we can get source information from a lot of different places. And I'm not saying that people with disabilities don't come forward. They do, But when you're entire being is reliant on the care of the people around you, complaining about them abusing you is really hard because you fear retaliation. So I wouldn't say we rely upon them. I say, though, when we are monitoring and when we are investigating in a setting that's a closed setting like that, a facility type setting, people don't try to get up in the morning and work in those settings because their goal is to try to hurt people that they care for. They often are trying, they're often overworked, they're trying to do a good job, and there's reasons why their job is difficult to do. I'm not saying there's not bad apples out there, and the regulatory system in our state and so forth is trying to weed out all of the bad apples, and that's an important facet of this. So when we conduct investigations and monitoring, one of the real critical components of our investigations, switching from monitoring to investigations, is, and one that we put at the highest level, is our responsibility to protect confidentiality. Because if we do not have that assurance, oftentimes people aren't going to talk to you and you're never going to uncover anything. And that's the confidentiality of the people who might be the subject of abuse and neglect complaints, as well as witnesses to that abuse and neglect. And so our entire investigatory process, we often get asked, are you investigating this? Or we heard in a newspaper article, somebody said you were investigating this place. We don't comment on any investigations that we conduct, ongoing investigations, whether we're investigating, because the responsibility on us is to keep the process confidential, so that people can be assured that we will protect that through the investigatory process. When we are done with an investigation, we may choose to make the results of that investigation public, primarily to protect the public, to give the public's knowledge about what we've uncovered, to try to ensure that that abuse doesn't continue or the neglect doesn't continue. But even if we were not to make it public, we make the contents of that investigation known to the oversight and regulatory entity. And it's not all, sometimes the oversight and the regulatory entity is the entity that we are complaining against, but it's not always true. And it isn't always true that that oversight and regulatory entity knows that there's concerns with the place. So just like the P&A system can't be everywhere all the time and know everything all the time, our oversight agencies have the same burden of the oversight departments within these large systems are often very small compared to the size of the large system that they're supposed to be monitoring. And so we might be informing them of things that they were not aware of through our investigations. So I wouldn't say we rely. I would say there's a cohesion to the responsibility. And I come from the school that everybody who's working in the system is trying to work in the system, maybe this is a little optimistic, in a way that doesn't abuse people, doesn't neglect people. Like, it's trying to deliver a service. This is a service delivery system. And you might find problems with the way in which those services are being delivered, but it is incumbent and the responsibility of the system itself to address those problems when they've been brought to light. And rarely, if ever, do we find that they try to obscure those or hide those problems without trying to fix them, right? So the goal of everyone, whether it's an oversight entity, whether it's a regulatory entity, whether it's a deliverer of service, is to deliver a service in a way that doesn't result in the abuse of people with disabilities.
So there's the investigation responsibility, the monitoring responsibility, advocacy, education. And one of the things that this podcast particularly focuses on is mental health laws throughout the United States. In New York, over the past several years, there's been a lot of activity related to expanding and redefining mental health laws. When something like that is happening, when you have in real time, you're seeing legislation changing, do you focus on maybe educating legislators, or do you focus on maybe talking to officials who are trying to interpret something? When things are changing in real time, and it seems like one of your responsibilities is really data collection and being able to provide people with evidence that patterns are happening. But if a policy has changed, you don't have any data yet because the new policy hasn't been instigated. So when that is happening in real time, legislation is happening like that, what sort of focus do you put on that sort of advocacy?
So I can address one that was in the relatively recent past down in New York City when Mayor Adams had instituted his policy of picking up people who appeared to have a mental health diagnosis and unable to care for themselves, mainly to, I guess, enhance the out of sight, out of mind policy that has been, a problem with New York City politicians, right? It was a problem with Mayor Giuliani, and then when Mayor Adams tried to institute this policy as well. As soon as that press conference happened and his administration had indicated it was their intent to work with the police department to remove people who couldn't take care of themselves and needed help, regardless of whether they wanted help or, no one had determined that any of these people were not capable of making decisions for themselves. Yet, we were foisting upon an untrained police force and transit authority force to make these split decisions to remove people. We met with the administration, and I think we had a very, very big impact on the pullback of this happening. We also partnered with advocates in the New York City area. We created a pipeline where if anyone was being affected by this policy, they had a direct line to our mental health project here at DRNY. So we have kept our finger on the pulse of this, and I think it really hasn't, developed into the nightmare that we all thought it was going to be. There are other problems. Jen, do you want to
Sure,
jump
I'll
in?
just jump in. When I was talking about that third prong of advocacy, one of the things that is really specifically set as a responsibility under that advocacy umbrella is educating policymakers about the impact of a particular policy, or in this case, your question, a law on people with disabilities. So, as we are a hub for complaints of abuse and neglect that come in, we're often contacted by policymakers. Sometimes, usually from the state legislature or from the federal representatives. Sometimes the state actively seeks out our opinion about something before they pass it, but oftentimes we will be one of the few that make public comment on any regulatory change or any proposals coming out of executive branch agencies related to people with disabilities. So we really are responsive to staying on top of policies that are coming out and the impact of it. Our addressing or pushing back on those policies can come in the form of litigation in order to push back against policies that we see are actually harming people with disabilities or could potentially harm people with disabilities. And that is true on both a local level, a state level, as well across. So things do change, but I can tell you in New York, there usually is a lead up to it, and we're aware of it, and we're a part of some discussions when it's happening. It doesn't mean that our thoughts are always what carries the day. Obviously, policies are sometimes rolled out without consideration of their impact. But at the end of the day, we do make our voices heard. And we encourage people, to the extent that these policies go in place that we believe might lead to some harm, we encourage them to contact us about those things. And we often make it known that if there is harm, that there might be a way of individually pushing back on the policy.
And we will often any entity that we have sued can never claim that they're surprised. They know well in advance what the issues are. They know what the relief is we're looking for and why it's supported by the law and why it should be done. Um, Although we are litigators, I've been a litigator my entire career, Jennifer as well. We also recognize that it takes time. And often during the life of a lawsuit, clients can die, right? And those are significant impacts on whether the relief will be obtained. So we do everything we can to try and resolve the issue without having to go to court. But there are times that we are not heard, and the things that we are asking for are usually not unreasonable. And at some point, we will be sitting across the table discussing this same issue, but we sometimes run into, why should we do this now when we can do it later from our adversaries? So that is a little frustrating for us because it is justice delayed. We try to achieve the result that will have the greatest impact, the positive impact on our clients as soon as possible. Um, Working with our electeds has increased over the years. I think one of the more unique issues in New York when the P&A system was created and all of those programs before the redesignation to one organization to ours, there were over 40 plus contracts that were distributed across, a dozen not-for-profits to provide the P&A services. Um, these were organizations that did good work, but their sole focus was not being the protection and advocacy system for New York State. When when we took it over in 2013, we changed our name. Our corporate name is Disability Advocates Inc. We changed our name to Disability Rights New York. I will say rarely, Jesse, are we sheep, but we agreed that a lot of our sister organizations around the country had started a movement to change their names to Disability Rights State, California, New Jersey, Connecticut, and in part to to be representative of a nationwide program, because that's what this is. It's a nationwide system that was created and that it exists in every state and territory, as Jennifer has said. Um, we have spent a large amount of time because people knew who disability advocates was back when we started in the 1980s and 1990s. But whether they completely understood that it was part of this federal program, because there were other offices like ours around the state that did good work, it's been only since we have really embarked on um, a big outreach program so that people know that the protection and advocacy system exists in New York State and that DRNY is that system, and that's where you need to come should you have a problem. Um, this has been an effort over the last, since 2013. It's 12 years, but we will continue to do it. I mean, partly because, as Jennifer said, we can and have the authority to knock on the door of an institution and do an unannounced visit. You don't have the resources to do that everywhere, but if you know we're watching, that may have, a positive effect to keep, to ensure that services are provided in an appropriate way.
Yeah, there's a through line, I think, from Willowbrook to today with evolving media in terms of visibility. When people see the problem, when they hear the voice and they can connect to the humanity of the person, most people want to change. Most people want to acknowledge that humanity. And the origin of this podcast was about 20 years ago. I went through involuntary hospitalizations and a civil commitment. And what I learned from that was I had no idea how any of it worked. And so my conclusion was stay invisible. Don't get noticed by the system. And that's the only way to make sure it doesn't happen again. When Mayor Adams did his press conference and he talked about expanding it, and I started looking at the language of the NYPD and their patrol guides, emotionally disturbed person, when to bring a shield, when to do this, when to do that. I was scared to walk around the city. And I know that as a white man, I'm going to blend in and be unnoticed a lot more than a lot of other people. But I know that history is there. It's following me. So anytime someone learns about that, and they have that idea, emotionally disturbed person. And so all of that is kind of a long way of saying that when I learned about protection and advocacy organizations, it was sort of like a revelation to me because there were people in a position where they could help someone like me be visible, where they could be on top of these changing laws and how unsafe it makes people like me feel, and they could help us like find our voice and they could advocate and protect. And so that is kind of why we I started doing this series, contacting PNAs throughout the country, because there was recently some reporting related to a leaked proposed budget from the Department of Health and Human Services, which suggested that funding might be cut to PNAs, which is frightening to me because PNAs are what I have to rely on in a way. And so as we wrap up, I wanted to bring this question to you. What would you say to someone, maybe from the federal government or maybe from state legislature or just anyone, who asked you, why do we need to have protection and advocacy organizations?
Because we're the only game in town when it comes to providing direct legal and advocacy services to people with disabilities at a time when they need it most. There may be other organizations that provide tangential services, but the types of services and authority that we have is non-existent anywhere else. And Congress recognized that back in the 1970s and then through the past 50 years with the addition of all these P&A services. Um, I share your concerns when that OMB budget, that document was released. Um, so I've been in this system since 1990 and, have seen budgets. The president's budget, which is ostensibly what that memo was a foreshadowing of, it was leaked, but I believe it was leaked purposefully to scare people, to lay groundwork for what they thought could be a steamroll effect on the budget. Regardless of which party is in office, Congress historically, I will say, takes their responsibility regarding appropriations very seriously. And I have been around and have dealt with direct attacks on the PAMI program. So the PAMI program is our program for people who have a mental health diagnosis. And back in the late 90s, early 2000s, there was a congressman from Pennsylvania who wanted to decimate the PAMI program. I mean, cut it by 85%. It was basically just going to be a research arm of SAMHSA, providing no direct services, because the narrative is when something bad happens, the go-to is to blame it on someone with a mental health diagnosis, when the truth is people with disabilities and people with mental health diagnosis are more apt to be the victim of a crime than the perpetrator of the crime. The people who are committing crimes are criminals. That is what is happening. It is really easy to scapegoat and maybe use, one example that is an outlier where maybe there was a mental health component of the particular crime, but that is often not the case. We have dedicated, targeted resources to beat back that narrative. Every year we create a congressional district report that lays out the services that we provide in each of the 26 congressional districts provide them to our electeds, and educate them on the value. So the P&A system is a tremendous return on investment. Like and I'll let Jen talk about this more because we just did a supplemental report to our congressional delegation regarding how we positively affect the use of federal funds in a good way and can address fraud, waste, and abuse. So, Jen?
Yeah, so I'll pick up where Tim left off. I will say but I wanted to start with your question about why do we still need a protection and advocacy system. I do occasionally hear this narrative, especially when you talk about institutional care from the 70s as what resulted in the creation of the system. I hear a narrative of everything must be fine now. Those are historical examples of abuse. And now, that abuse would not happen. And I think I would, in response to that, identify something Tim said, which is when you are watching, you are less likely to have someone create a system that has rampant abuse in it. And it is the oversight that does result in a reduction in abuse and neglect within those systems. And so I would argue that without the P&A system, you would be seeing a different level of care and treatment in settings that people with disabilities receive that care and treatment than you are seeing right now. And it is that oversight that has kept the services and the funding needed to deliver those services in place for people that are in those settings. Because as I think you've just described your experience, when you are in a setting where you're relying upon the other people around you to provide care to you, and you are cut off from your family and loved ones in that setting, you feel very beholden to the people in that setting, and you are inclined to put your head down and ignore everything that's happening around you. And if there was not independent oversight of that system, things happen, things continue to happen. And even though we do uncover abuse and neglect now, where we are uncovering it are in those settings where there isn't oversight. It isn't in settings that are heavily monitored. And abuse and neglect is extremely costly to taxpayers, not just in the damage it causes to the citizens and our community members, but it is often financial abuse and neglect that you are seeing at the same time as physical and emotional abuse of people. And so it's wasting our taxpayer dollars in a system that is not delivering upon its promise. So today, I do think that the system is as valuable today to push back on actors who deliver it in an improper way and permit the federal government to have eyes and ears in our states and territories to make sure that the federal dollars that we all contribute to as taxpayers are not being used to abuse people with disabilities.
Was it Ruth Bader Ginsburg who made the analogy that if you were to get rid of your umbrella because you're not getting wet during the rain, you're just going to create a new problem? The protection and advocacy organizations, you are that umbrella, and that's why we need you. Tim, Jennifer, thank you so much for being here, and thank you for doing the interview.
Our pleasure. Thank you for having us.
Thank you.